أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم رب اشرح لي صدري ويسر لي أمري واحلل عقدة من لساني يفقهوا قولي. So in our lesson today, we shall be talking about one of the most important part of our lesson, and that is the international humanitarian law, which is also known as the law of armed conflict or the law of war. Now, as we cover this topic today, this shall be our lesson's objective. So, number one, by the end of the lesson, learners should be able to define international humanitarian law. And when you're talking of international humanitarian law, this is the law of law or the law of armed conflicts. Number two, describe the historical development of the law of war. Number three, identify and explain the main sources of international humanitarian law. Then explain the objectives and importance of international humanitarian law in armed conflicts. Then differentiate between international and non-international armed conflicts. Then lastly, explain the fundamental principles of international humanitarian law. So in brief, this is going to be our objectives. It is going to be the blueprint that shall be guiding us in this lesson. Now, so number one is the definition or an introduction to the international humanitarian law. So the international humanitarian law, okay, also known as the law of armed conflict or the law of war, is a branch of public international law. Remember, in our last lesson, we talked about what? We talked about the classification of international law, and we said that we have the private international law and we have the public international law. So it is a branch of international law that regulates the conduct of armed conflict. So it is a law that actually regulates the conduct. By conduct, we mean what? The behavior of armed conflicts. It seeks to limit the effects of warfare. So in any war, we normally have people dying, people getting wounded or injured, but the main objective of this law is to limit. Limit means to minimize. How? By protecting persons who are not or are no longer participating in hostilities, by restricting the means and methods of warfare. So that is in brief the word. That is in brief an introduction to the international humanitarian law. Now, according to the International Committee of the Red Cross, how did they define the international humanitarian law? How did they define it? So they define it as a set of rules, majmu'atul qawaid aw al-qawanin, a set of rules which seek for humanitarian reasons to limit the effects of armed conflict. This is just what we saw in the introduction. So because of humanitarian reasons, we want to give people food, we want to give people shelter, we want to limit the effects of war, of armed conflict. So it protects persons, people who are not or are no longer taking part in hostilities, and restricts means and methods of warfare. So that is the definition of the International Committee of the Red Cross. Now, the international humanitarian law applies only during armed conflict. Full stop. This is a very important point. We only apply this law during armed conflicts, whether it is international or non-international, and does not regulate whether a war is lawful, that is governed by just ad bellum under the UN Charter, but rather how war is conducted. So the international humanitarian law, this is very important, does not regulate whether the war is halal or haram. No, that is not the responsibility of the international humanitarian law. The main objective of the international humanitarian law is to do what? To just determine if this war is it being conducted in a right way or a wrong way. Full stop. Now, during your free time, you will review this video. So there is a video in YouTube that is actually describing or defining the international humanitarian law. So you will, after the lesson, please review this video. Now, remember, when we were defining the humanitarian law, we talked about two important things. You know, we talked about jus ad bellum and jus in bello. Now, what is it in an exam? In an exam, you can be asked about this. What is the difference between jus and bellum and jus ad bellum and jus in bello? You can be asked in an exam. What is the difference between these two words? Okay, now let us see what's the difference. Number one is jus ad bellum. Jus ad bellum refers to, underline this, the right to go to war. The legal justification for a state to use armed force. Like, what is the right to go to war? Like, when is it halal to go to war? Huh? So under the UN Charter, United Nations Charter, Article 2, brackets 4, generally prohibits the use of force. You cannot attack a country, no, mustahil, mamno. But Article 51 and 42 allow exceptions. So these are the only two times, or these are the only two, these are the only two times when you can attack, or these are the only two times when you can go to a war. Number one, self-defense. If a state is attacked, that is in Article 51 of the UN Charter. So if a country attacked you as Somali, then you have to defend yourself. You cannot just sit down and somebody is attacking you. No. So it is called self-defense. Even in your house, you know, if people attack you, no, you cannot just sit and say, okay, lillah, lillah, fillah. No, not lillah, fillah. You need to attack. Then number two, UN Security Council authorization. That is in Article 42, to maintain international peace. So the UN Council can meet and they can decide that country A has to be attacked. Why? Because of international peace. Peace cannot be there if country A is not going to be attacked. So those are the two circumstances. So when you're talking about jus ad bellum, right to go to war, it is clearly mentioned these are only the two circumstances. So for example, if country A is invaded by country B, country A has the legal right under jus ad bellum to use force in self-defense. Ma'ada dhalik, you cannot go. You cannot use force. Now, the opposite, jus and bello. Jus and bello refers to the law governing conduct during war. And this is our focus today in our lesson, the international humanitarian law, or the law of war, or the law of armed conflicts. So it refers to the law governing conduct during war. Like when you are fighting, what is halal, what is haram when you are fighting? For example, in Islam, you should not cut the trees. You know, you should not kill the women. You should not kill the children. You should protect the humanitarian workers. That is what we are going to talk today. So, law governing conduct during war, focusing on how hostilities are carried out, regardless of the reason for war. So, jus and bello, the international humanitarian law, it does not care why are you fighting. It cares with how are you fighting? So it cares with how, al-kayf. It does not care with limadha. Limadha al-harb. That's not in international law, international humanitarian law. So under the UN Charter and international humanitarian law, parties must follow international humanitarian law principles, distinction between civilians and combat, proportionality and humanity, as we shall see later. So, example, even if country A is defending itself, it cannot intentionally target civilians or use indiscriminate weapons. So, even if you are defending yourself, that is not the license to kill innocent people just because, like what Israel is doing with Gaza and Palestine, or self-defense, and in the process, you are killing women, you are killing small children, you are killing the journalist just because, khalas, we have the right to defend ourselves. No, that is not how things should be working. Now, you will find this, watch this video. This video in YouTube will explain to you the distinction. So, jus al bellum, whether it is legal to go to war, and jus in bello, how war is legally conducted. So this video, if you watch it, it will clearly explain to you the difference between the two. Okay, now quickly, the historical development of the law of war or the international humanitarian law. So the law of war has evolved over centuries as a response to the human suffering caused by armed conflict. So how did the law of war? Number one, we have the ancient and religious origin. Then number two, the 19th century and modern international humanitarian law. Then the Hague and Geneva tradition. Then the post-World War II developments. So this is the historical development. So before there was any law, religion, ad-din was there. For example, as in Islam, even before the UN was there, in Islam, it was very clear the conduct of war. Like even the Prophet ﷺ, when he was fighting battles with the non-Muslims, non-believers, the law of war was very clear. Don't cut trees. Don't kill the women. Don't kill the children. People who have surrendered, leave them. The prisoners of war, don't actually attack them. Give them food. Take good care of them. So that was the first part. Number two, then the 19th century. The 19th century, of course, there was a war that actually happened in the 19th century. And the war was between Italy and Austria. And and because many people were dying, there was this guy called Henry Dunant. He's one of the founders of the Red Cross. So he came with the idea, Jama, many people have died. We need to help them. So it was the creation of the international community of the Red Cross. And this Henry was the founder. Then after that, there was the UN. There is the Hague law and there is the Geneva law. It is clearly mentioned the conduct of law. So during your time, go and review the Geneva the Geneva articles. They have Geneva 1, 2, 3, and 4. It is explaining what is expected. Then post-World War II, again they developed the four Geneva Conventions of 1949. During your free time, read these four Geneva. It is the one that is guiding the law of the humanitarian law. Now, this also, the Battle of Solferino. During your free time, watch this video. So it is basically explaining how the international humanitarian law, it is basically explaining how the law of war started. So it was during this war. This war was a turning point. Now, sources of international humanitarian law. So remember in our last lesson, we discussed about the 4 sources. Even here, the sources are just the same. The sources of international, they are 4. Number 1, we have the international treaties. And this is the most important one. I need you to go and review it, the 4 Geneva Conventions. Of course, we shall be referring to them. They are inside this lesson. But during your free time, go and review all this. So we have the international treaties. These are the ones that are guiding us. Like if you want to determine the conduct of the armies and the soldiers during the war, then it will really help a lot. Then you have the customary international humanitarian law, the general principle of law, the judicial. In our last lesson, we explained this in detail. But the most important thing when it comes to the law of law is the first one, the international treaty, especially the 4 Geneva Conventions. Now, this is important. What are the objectives of the international humanitarian law? The main objective, number 1, is to protect civilians and non-combats during armed conflict. For example, if there is a war, for example, between the Israel and the Palestine, what is the responsibility of this law? To protect the civilians. And non-combat. Non-combat means people who are not fighting. So we need to protect them. Number 2, to limit the means and the methods of warfare. To limit the means and the methods of warfare. To limit the weapons coming in. Because the more the weapon, it basically means the war is going to continue. We need to limit the methods of war, be it by land, by air, by water. We need to limit. If we limit it, then we are not going to have a lot of casualties. Number 3, to ensure humane treatment of prisoners of war and the wounded. During war, we normally have prisoners of war. They need to be treated. They need to be taken good care of. The wounded, people who have been injured, they need to be taken good care of. Then lastly, to balance military necessity with humanitarian consideration. Yes, there is war, but there need to, is it military necessity? Basically means, do we have to use that force? Because fi athna al-harb, when the fight is going on, there are people who need medicine, there are people who need shelter, there are people who need food. So we need to balance these two. So that yes, the war is continuing, but yes, also on the other side, but it is not happening. Look at Gaza, look at Palestine. These things are just written, but fil ard al-waqi', it does not exist. Because if they were implementing this, then Israel should not actually be doing what it is doing. Now, what is the importance of the international humanitarian law? Number 1, reduce human suffering during war by giving them food, giving them shelter, taking good care of them. Protects human dignity. Because during the time of war, women, sometimes they are raped. But with this law, it is there to protect these women. Promote international peace and security, provides a legal basis for prosecuting war crimes. So this war, it gives us the basis. For example, if you want to take somebody to the International Court of Justice, so we can say that they didn't, like South Africa, for example, they took Israel to the International Court of Justice basing on this international humanitarian law. That is, Israel did not conduct themselves in the right way. In fact, they are committing genocide. They have evidences of how Israel is conducting themselves in the war. Then, guides military conduct in Africa, the Middle East, and umuman global conflicts. Now, another important thing is the classification of armed conflicts. Are all the conflicts in this world the same, or they're different? So, international humanitarian law applies only when an armed conflict exists. For legal and practical purposes, armed conflicts are classified into 2. Number 1, international armed conflicts. Number 2, non-international armed conflicts. Yeah. Okay. Now, what is the difference between the two? International armed conflict occurs whenever there is armed confrontation between two or more sovereign states, regardless of whether a formal declaration of war exists. So international armed conflict, it occurs between either two or more states. For example, if Somalia is having a war with Ethiopia and Djibouti, that is an international armed conflict. Three independent countries are involved. You know? Now, under additional Protocol 1997, Protocol 1, 1977, the international armed conflicts includes wars of nation liberation, where people fight against colonial domination. For example, the war between Somaliland and the British, or the Somali and the Italy. The war for because you want independence. That was an international armed conflict. A land occupation, foreigners occupying your land. If somebody comes to occupy your land, then that is an international racist regime. إلى غير ذلك. Now, what are the key characteristics? So it involves two or more states. Then there is the full application of the 4 Geneva Conventions of 1949. Then combats captured by the enemy are entitled to the prisoner of war status. Then civilians receive extensive protections, and applies even one party denies the existence of war. Now, and we have a lot of examples of this war. We have Russia, Ukraine. It's an example of international armed conflicts. Indian-Pakistan war in 1947-65, Iran-Iraq war, Gulf war in 1990. So all these are examples of what? The international. Then non-international armed conflicts occurs within the territory of a single state. For example, that is government armed forces and organized armed group. For example, in Somalia, the war between the government and Al-Shabaab, that is a non-international armed conflict. And among the characteristics of this, it takes place within one state. It is inside Somalia, that war, that conflict. It does not involve two or more states directly. Then lower legal threshold. So even if you go to the International Court of Justice, the legal threshold is not that strict compared to the international armed conflicts, And there are very many. You have Syrian civil war, Sri Lanka, all the civil wars because they are inside the country. Colombian armed conflicts. Now, classification of armed conflicts, you'll watch this video. It will guide you more. Now, fundamental principles of international humanitarian law. This is very important. If you want to understand the law of war, you need to understand these 4 principles. It's very important. Number 1, principles of distinction. This is al-mabadi at-tamyiz. So, the principle of distinctions requires parties to an armed conflict to distinguish at all times between combat and civilians, and between military objectives and civilian objects. Only combat and military objectives may be lawfully attacked. Civilian and civilian object must not be targeted. So this principle is codified in Article 48 of Additional Protocol 1, 1977. So the principle of distinction, tamyiz, during war, we have to know that these are civilians, these are normal citizens, and these are the army, this is the military. Now, these are the houses of civilians, and these are, for example, the assets and houses of the military. So you target the military, you target the armed forces, you target their houses, you target their barracks where they stay. You cannot target the houses. Look at what Israel is doing in Palestine. Look at what the Rapid Support Forces is doing in Sudan. There is no distinction. Women are being killed in the process. The babies are being killed. They're not applying this principle. They should be fighting with the army. They should not be fighting with the civilians. That is a disaster. Number two, principle of proportionality. Like when you are talking about proportionality, the principle of proportionality prohibits attack that may be expected to cause incidental civilian harm that will be excessive in relation to the concrete and direct military advantage anticipated. So when we are talking about proportion, yes, you can attack, but it should not be excessive. Like for example, when you are attacking, you can bomb a place, but if you are going to attack this place and civilians are going to be attacked, then that is proportionate. And that is the same thing. This principle was not applied by Israel when attacking Palestine. They attack, they bomb a place, and they kill hundreds of civilians. So it was not proportionate. Proportionate also requires you not to use heavy machineries or artilleries, but that was happening. Number three, principle of military necessity. So the principle of military necessity allows the use of only that degree and kind of force required to achieve a legitimate military objective, provided it is not prohibited. Now, for example, destroying a bridge used by enemy forces to transport weapons may be justified by military necessity. However, destroying hospitals or cultural monuments that serve no military purpose cannot be justified under this principle. So, principle of military necessity basically means, for example, if this bridge, the enemy, they are using this bridge, to bring weapons, we can decide to bomb that bridge because that bridge is actually causing more harm than good. But it is not a military necessity when you are going to bomb the hospitals, when you are bombing the schools. That is not a necessity. But unfortunately, look in Israel. Look what happened in Palestine. And the whole world is just keeping quiet. They're just there sitting, watching. And this is in the United Nations. So it is very painful. Okay. Principle of humanity. This is the last principle. The principle of humanity requires that human suffering be minimized during armed conflicts. It prohibits the infliction of unnecessary suffering, cruelty, torture, and inhumane treatment. So this principle underlies many rules of international humanitarian law, including the protection of wounded soldiers. For example, if there are some soldiers, they are wounded, they need to be taken care of. The prisoners of war. But in Israel, they take prisoners they arrest people from Palestine, they take them to prisons in Israel. Are they taken good care of? So, for example, providing medical care to wounded enemy soldiers demonstrate respect for the principle of humanity. Practices such as torture of detainees or execution of prisoners violate this principle. So this is the summary of the four principles: the principle of distinction, proportionality, military necessity, and principle of humanity. Now, during your free time, you can watch this video in YouTube. It is explaining this principle in detail. Okay. That is the end of our lesson. If there is any question, you can ask. If there is any question, you can ask about this principle or about the the types of international law. So if you have any question, please, you can ask. Is there any question? And please, you have to review all these videos. You need to review these videos to get a clear understanding of this word, of this law, the law of laws, and you need to research more. You cannot be satisfied actually with what we are actually teaching you in class. So the more you read, the more you research, it's going to open your mind. You are going to understand this law clearly. Okay. Now I'm going to send the attendance in your group. I'm going to send the attendance. Please take the attendance. Some students are not taking the attendance and they are losing the attendance mark. Remember the attendance.
Sorry, Ustad, you not share with us the last class. I think so. There is no any attendance sheet. You share it the last class.
Lesson 2?
Yes.
Shared. Can you? Maybe you are not there. Just ask the other student. Which class is this? International relationship or?
International relationship.
Are you sure?
Yeah, I'm sure. Because I am attending the class. I'm not see it. I reviewed the chatting, so I didn't find it.
Okay, that is it. Let me check. Maybe I did not send it. Let me check just now. International relation. Yeah, I will send it. Yeah, I have just seen. I did not send it, but today I have sent it. You can check it. So just a minute. So the international relationship I've sent. Criminal law I've sent. Then again, yeah, so that is it. So I will also send the attendance for lesson 2. I'll just send the link now in your group. I did not send it here, I've just seen it. Okay, so don't worry. So is there any other concern? So if there is no any other concern, we'll meet tomorrow, inshallah. Okay, wassalam.